I was talking to a friend, Sarah, who worked at this high-end tech firm in San Francisco.
Right.
And, she'd been there for 3 years, never missed a deadline, and had just gotten this, glowing performance review.
So a model employee by all accounts.
Totally. Then, one Tuesday, her manager calls her into his office, leans back in his expensive leather chair, and he simply says, "We're letting you go. Effective immediately."
Ow. Out of the blue.
Completely out of the blue. So Sarah, she's stunned, obviously. She asks for a reason. And he gives her this cold, almost bored shrug.
Total.
And he says, "California is an at-will state, Sarah. I don't actually need a reason. I just don't think you're a culture fit anymore."
The culture fit line, the ultimate catch-all.
He said it with this absolute certainty, like that one phrase at will was some kind of magic shield that made him bulletproof.
Right.
He even offered this small, sympathetic smile as if he were explaining a simple rule of physics to a child. To him, the law was just a green light to do whatever he wanted.
And Sarah was just another person who had to accept the raw deal.
She walked out of there feeling completely hollow. To her, at will sounded like this legal loophole that allowed bosses to just act like petty dictators.
Which is how a lot of people feel. If they don't like your attitude or you stand up for yourself, you're out. You just have to pack your desk.
That's what she figured. But here's where the story takes this sharp, unexpected turn.
Yeah.
What her manager conveniently ignored, or maybe didn't even realize, was that just 10 days earlier, Sarah had filed a formal written complaint.
What?
A series of safety violations in the warehouse.
Ooh. Everything.
That smug confidence in the at-will doctrine. It was about to run headfirst into a reality that a lot of employers, and way too many employees, completely misunderstand.
It creates a seismic shift in the power dynamic.
It's an instantaneous shift, right? From a manager feeling untouchable to a company suddenly facing a massive legal liability. And it happens more often than you'd think.
It does. Because in California, while at will is the starting point, it is so far from the final word.
There is this massive hidden line between a bad reason and an illegal one.
And knowing where that line is changes everything. That story about Sarah is, it's the perfect crystallization of the gap between the mythology of employment law and the actual mechanics of it.
The mythology.
Because there is this persistent idea, especially in management circles, that at will is synonymous with absolute power. It's this belief that you can wake up one morning and fire someone just because you don't like the color of their shoes, and the law has your back.
That is the magic shield idea. The manager thinks he's Caesar.
Exactly. But that shield, it's porous. In California specifically, the exceptions to the rule have, for all practical purposes, swallowed the rule itself.
So let's be clear on that. What's a valid reason versus an invalid one?
An employer can fire someone for a personality conflict. They can fire you because business is slow. They can fire you because they think you're a bad culture fit, as awful as that sounds.
Those are all bad reasons, maybe, but not illegal.
Right. But they cannot fire someone based on protected characteristics, gender, age, and this is the crucial part for today's deep dive, they can't fire you for engaging in protected activities.
Like filing a safety complaint.
Exactly. Or whistleblowing, or discussing your wages with a coworker, or filing a complaint about harassment. These are the third rails. The moment Sarah filed that safety complaint, she moved from being just an at-will employee to being, essentially, a protected class of one.
So her manager's decision to fire her 10 days later, even if he genuinely, in his own head, believed it was about culture fit.
The legal system is going to view that through a completely different lens. The timing is just too suspicious.
And that's what we're going to get into. We're exploring the unintended consequences of these protections. We aren't just looking at the statutes themselves. We're looking at how these well-intentioned laws designed to stop discrimination and retaliation, how they create these massive structural shifts.
And how companies behave, how managers think, and ultimately the psychology of the workplace itself.
We have to move from the legal theory, the black and white text of the law, into the messy reality of the modern office.
And to kick this off, I think we have to talk about what happens when meritocracy runs headfirst into risk management.
I have a perfect story for this. Imagine one of those sleek, glass-walled offices in Palo Alto, the kind where the espresso is free, but the pressure is just suffocating. I heard this story recently about a mid-level engineering manager, let's call him David, who found himself caught in this paralyzing corporate paradox.
Okay.
So David had a team member, we'll call him Alex, and Alex's code was just consistently breaking production. It wasn't malice, it's just a clear lack of technical ceiling. The guy just wasn't cut out for the role.
A classic performance issue. Happens all the time.
And it should have been a straightforward, standard performance issue. But the moment David initiated a formal performance improvement plan, a PIP?
Which is what HR tells you to do. Document everything.
Right. The moment he does that, Alex, who was apparently very well versed in California's anti-retaliation statutes, files a formal grievance.
A grievance for what?
Claiming stress-induced disability and hostile management.
Is the magic words.
Suddenly, David wasn't a manager trying to maintain a high-performance culture anymore. He was a potential legal liability walking around the office.
And Alex, the underperformer, was effectively untouchable.
For 6 months. For 6 months, the underperformer remained on the payroll, totally untouchable.
And meanwhile, the rest of the team is watching this whole drama unfold.
They're not just watching, they're living it. The high achievers on the team, they grew incredibly resentful.
They're picking up the slack.
They were cleaning up the mess, working late to patch Alex's bad code, and watching their own bonuses dwindle because the team targets were being missed. And they couldn't even criticize him.
Because of the pending grievance.
Exactly. The whole incentive for excellence was just. It was replaced by a strategy of legal self-preservation. David essentially had to construct what he called a shield of mediocrity around this one employee to protect the company from a lawsuit.
But we need to really understand the legal mechanics here. David's paralysis, it isn't just him being timid or a bad manager.
No, it's a rational response.
It is a perfectly rational response to a specific piece of legislation. Senate Bill 497.
SB 497, the Equal Pay and Anti-Retaliation Protection Act.
This law fundamentally changes the entire battlefield. It does it through a mechanism called a rebuttable presumption of retaliation.
Okay, we absolutely need to define that clearly. That sounds like dense legal jargon. What does a rebuttable presumption actually do in a courtroom?
It's actually pretty simple once you break it down. In the past, under standard law, if you claimed I fired you in retaliation for a complaint you made,
you, the employee, had the burden of proof.
Yes. You had to show the link. You had to find the smoking gun email where I said, I'm firing him because he complained about the safety issue. You had to prove my intent.
Which is really hard to do.
Extremely hard. But SB 497 flips that entire burden. It states that if an employee is disciplined or fired within 90 days of engaging in protected conduct, like filing a complaint about stress or wages or safety,
the law presumes the action was retaliation.
It presumes it. The default setting is that the employer is guilty.
So the burden of proof shifts entirely to the employer.
It's just 180 degrees. The employee doesn't have to prove retaliation initially. The employer has to prove they didn't retaliate. So in David's case, think about the timeline.
He starts a performance improvement plan. That's a disciplinary action.
Then Alex files a grievance about hostile management.
That's protected conduct.
Now, David is frozen. If he fires Alex within the next 90 days, the court automatically assumes it was retaliation unless David can prove otherwise with clear and convincing evidence.
And proving that I didn't fire him because of the complaint, that seems notoriously difficult.
It's incredibly expensive and incredibly risky. And to add another layer, SB 497 also attaches a $10,000 civil penalty per employee for violations. And it's on top of any other damages.
So David's company, they're looking at this and they're just doing the math.
They're doing the risk calculus. They're thinking, okay, option one, we fire this guy, we have to hire lawyers, we have to fight a presumption of guilt in court, and we risk massive fines.
Option two, we just keep him.
We keep him and we just lose some productivity.
Yeah.
For most companies, the rational business decision, the risk management decision, is to keep the bad employee.
Wow. And that creates what you call the documentation paradox.
Exactly. All the big legal firms like Squire Patton Boggs, they advise employers to document everything. They say discipline progressively, write it all down, create a paper trail.
Standard HR practice.
Right. But in practice, under SB 497, the moment David starts documenting the poor performance, he triggers the very mechanism that protects the underperforming employee. The employee sees the PIP coming, they file a stress claim, and boom, the 90-day clock starts, and they're untouchable.
The tool you're supposed to use to solve the problem is the very thing that makes the problem unsolvable.
It's a legal catch-22.
This connects so directly to the research I was reading from Wang and Young on wrongful discharge laws. They talk about this concept of operating flexibility.
And that's a perfect way to frame it. Operating flexibility is simply the ability of a business to adjust its workforce based on reality.
Reality being performance, market demand, changes in technology.
The ability to hire the right people and, just as importantly, fire the wrong people. Wang and Young found that these laws, these WDLs, they impair that flexibility significantly. They effectively impose a tax on employers.
And not a literal tax that you paid to the state, right?
No, it's an implicit tax, an invisible tax. Every single person you hire now comes with a potential future cost baked in. The cost of severance, the cost of legal defense, the rising insurance premiums.
And maybe more importantly, there's the cost of not firing. Keeping an underperformer like Alex on the team is a tax on the productivity and morale of everyone else.
That's the part that really destroys the culture from the inside out. The high performers see that competence isn't the primary currency in the office anymore.
Legal leverages.
Legal leverages. That is the erosion of meritocracy. When you replace the question, who is doing the best work, with the question, who is the biggest legal risk to fire, you completely destroy the incentive structure of a company.
You're actually punishing the best employees.
They have to do their own work plus the work of the person who can't be fired. Meanwhile, the worst employee is protected, shielded by the company's fear of litigation. It flips the entire logic of business completely upside down.
It's a structural failure of incentives. And, this moves us into a deeper, almost more sociological territory, because it's not just about legal tactics anymore. It's about how we, as a society, are starting to define intolerable conditions in the workplace.
This is where the legal system starts to actively reshape our psychology.
Yeah.
It's not just reflecting values, it's creating them.
I was reading this thread online about the death of grit in the modern workplace, and it featured this really telling narrative from a startup founder in Santa Monica.
Okay.
She was describing a constructive discharge claim that was brought against her by an early hire.
We should probably define constructive discharge before we get into the story.
Also, legally, constructive discharge happens when an employer makes working conditions so intolerable that a reasonable person would feel forced to resign.
And, originally this was meant for really egregious things.
Right, like constant sexual harassment or massive unaddressed safety violations or, taking away someone's desk and making them sit in the hallway, things that no human should have to endure.
Objectively terrible conditions.
Exactly. Well, in this founder story, the intolerable condition that was cited in the claim was that she had requested the employee return to the office 2 days a week.
Okay, that's becoming more common.
And that she had once used a curt tone during a deadline crunch.
A curt tone.
A curt tone. That was the basis for the intolerable conditions claim.
So standard professional pressures are now being labeled as legally intolerable.
And in this legal climate, the definition has expanded so far into the subjective that it essentially mirrors this broader critique of what's called the therapeutic state.
And what was the outcome for the founder?
She ended up settling out of court. She told me the real cost wasn't even the money. It was the realization that she could no longer demand professional resilience from her team without risking a lawsuit.
Wow.
She said she felt like she was running a daycare for adults rather than a competitive business.
A daycare for adults. I mean, that is a stinging indictment. But to understand why she feels that way, and more importantly, why the law might actually support that employee's claim, we have to look at this phenomenon of subjectivity creep.
Subjectivity creep.
It means the legal bar for what counts as intolerable is being lowered year by year to include what used to be considered standard management friction. Being told to come into the office or being told this work isn't good enough in a stern voice.
Things that are necessary to run a business.
Exactly. Those things are now being reframed as psychological injuries.
This is where the writer Christopher Lasch becomes just absolutely vital to this conversation. We're looking at concepts from his books, The Culture of Narcissism and The Minimal Self. And I mean, Lasch was writing decades ago, but it feels like he predicted this exact moment.
He really did. Lasch wrote about the rise of what he called the therapeutic state. He argued that modern society has shifted its focus away from character, building resilience, moral fiber, learning to deal with adversity, to a focus on survival and psychic well-being.
And this is his concept of the minimal self.
The minimal self. Exactly. The minimal self views the entire world as a series of impending crises. The goal of life isn't to build something great or to endure hardship for some higher purpose. The goal is simply to survive the emotional onslaught of daily life.
So under this worldview, the self is seen as fundamentally fragile. It's a victim of outside forces.
It's always a victim. So when that startup founder uses a curt tone, The employee doesn't hear, my boss is stressed about the deadline, I should probably step up my game.
No, they hear, I am under attack, my psychic survival is being threatened.
Precisely. And this links directly to what the psychiatrist Thomas says called the medicalization of deviance.
The medicalization of deviance.
It's the idea that we've taken what are essentially social or moral problems, like being a bad employee or having a tough boss or just having a simple personality conflict, and we've turned them into medical or psychological issues.
So it's not, I don't like my boss anymore.
No, it's my boss is creating a toxic environment that is causing me trauma and emotional distress.
And as soon as you use the language of therapy words like trauma, toxicity, unsafe space, you immediately trigger the legal protections we were talking about earlier with SB 497.
You're speaking the language of the law now. And thinkers like Frank Furedi and James Nolan, they discuss this extensively. They talk about how HR departments have essentially become therapeutic managers.
What does that mean, a therapeutic manager?
It means HR is no longer primarily there to ensure the job gets done efficiently. They're there to engage in defensive practices. Their main job is to manage the psyche of every employee to avoid a potential lawsuit.
Which explains exactly why that founder felt like she was running a daycare. If a manager cannot give critical feedback without fearing a claim of constructive discharge or emotional distress, then they just stop giving critical feedback.
They start coddling. They avoid conflict at all costs.
And this is the sociologically fascinating and frankly kind of terrifying part. By shielding employees from all discomfort, the entire system normalizes fragility.
Resilience is like a muscle, right? It only grows when you stress it. If the legal and therapeutic structure treats every single stressor as a pathology, as something that should not happen, then employees never develop the thick skin required to be professionals.
It effectively transforms the workplace from a place of business into what James Nolan called a problem-solving court.
Tell me more about that parallel.
Nolan's critique was that these courts moved away from adjudication, determining who is right and who is wrong based on evidence, and moved toward therapy. How do we heal the actor regardless of their actions?
So in the workplace, this means managers can't simply enforce standards. They can't just say, this is the bar and you failed to meet it.
No, they have to heal the employee's relationship with the work. They have to manage their feelings about the feedback. And for a startup founder who's trying to survive in a cutthroat market, that is an absolutely impossible burden.
It raises a huge question about our overall competitiveness. If we create a workforce that views ordinary professional friction as intolerable, we are putting ourselves at a massive, massive disadvantage. But, for some business owners, they aren't waiting around to see the long-term sociological effects.
They're just leaving.
They're just leaving, which brings us to the hard, cold, economic reality of all of this.
I'm thinking of a story I heard about a guy named Marcus. Marcus is the owner of a family logistics firm down in Riverside. He's a guy who has built this business from the ground up over 30 years. Salt of the earth.
Okay.
But recently, he just hit a wall. He had to fire a driver for documented safety violation. I mean, real issues, dangerous driving, things that put the public at risk.
So he had a solid, documented, business-related reason.
But the driver sued for wrongful termination, alleging retaliation for some minor maintenance comment he had made months prior.
The retaliation claim again. It's the go-to move.
It's the go-to. So Marcus sits down with his lawyer, and the lawyer just lays it out for him. He says, look, even if we win this lawsuit, even if a judge agrees you are 100% right, it's still going to cost you $50,000 in legal fees.
And that's because of the American rule and law.
Exactly. In the U.S., each side generally pays their own legal fees, win or lose. So the at-will defense, even when it's valid, is incredibly expensive to prove in court.
So Marcus is looking at a $50,000 bill just to prove he was innocent.
He looked at that $50,000 bill. He looked at the rising cost of his employment liability insurance, and he made a decision.
What did he do?
He liquidated his California assets and moved the entire company, all 40 jobs, to Arizona.
Ow.
And he was explicit with me. He wasn't leaving because of the weather or the income tax. He told me, I am leaving because the legal risk of a single hire became an existential threat to my family's business.
And that phrase, existential threat, is not an exaggeration for a small business. If you are a massive tech firm, a $50,000 legal bill is a rounding error. It's in the budget.
It's the cost of doing business.
Right. But for Marcus, $50,000 is a new truck. It's payroll for a month. It is the literal difference between being in the black and being in the red for the year.
And the data, it really supports this. It's not just an anecdote about Marcus. We have that Wang and Young study on wrongful discharge laws, WDLs, and how they affect venture capital.
This study is so crucial for understanding the macro-level impact. They looked at what happens to investment when states adopt these good faith exceptions and other wrongful discharge laws that make it harder to fire people.
And what did they find?
They found a roughly 33% decline in the dollar amount of venture capital investment flowing into those states.
A third. A third of the VC money just vanishes.
It makes perfect sense if you think like an investor. They need to be able to pivot, to scale up, or scale down incredibly rapidly. They need that operating flexibility we were just talking about.
The ability to hire and fire quickly.
Yes. So if a state makes it legally treacherous and expensive to fire people, a VC looks at that and says, this venture is now too risky. If they hire the wrong team, they're stuck with them, and my investment goes to zero. High distress costs make risky ventures unfundable.
So the money just goes elsewhere. It goes to states with more predictable legal environments, just like Marcus went to Arizona.
Exactly. And it's not just about the employment laws in isolation. It's a bigger phenomenon called regulatory accumulation.
Okay.
The Pacific Research Institute has this incredible visualization that perfectly illustrates the problem. They chart the number of pages in the Code of Federal Regulations against the number of jobs gained by new startups over time.
And I'm going to guess the lines go in opposite directions.
It is a stark, undeniable divergence. As the number of pages, which is a proxy for complexity, goes up, the number of jobs created by startups goes down. Complexity itself acts as a massive barrier to entry.
So,
because large incumbent corporations can afford big HR and legal departments. They can afford employment practices, liability insurance, or EPLI. They can amortize the cost of compliance across thousands of employees.
but for the small business owner, the startup founder, for Marcus,
Every new regulation, every new page of the legal code is another hurdle he might not be able to clear. It's another potential lawsuit waiting to happen.
So the regulations that are supposed to protect workers from the power of big corporations, they actually end up protecting big corporations from new competition.
It's a huge paradox, but yes. The complex legal environment cements the status quo because only the giants can afford to navigate it and survive.
And so Marcus moving his company to Arizona isn't a political statement. It's just a rational economic calculation. The price of employing someone in California includes this massive litigation premium that he simply couldn't afford to pay anymore.
And that premium is priced into every single hire, which goes a long way to explaining the demographic outflow we see. It's an economic exodus driven by the escalating cost of liability.
Now, as if that wasn't complicated enough, we have to look at the current landscape. It is 2026, and the legal environment has become, it's a minefield of contradictions.
It has become incredibly messy. What we're seeing now is a direct clash between federal and state directives that leaves employers in a complete no-win situation.
You're talking about the Trump administration's Executive Order 14281, right? Restoring equality of opportunity.
That's the one. It's a direct frontal assault on the concept of disparate impact liability and many DEI initiatives.
So the federal government is essentially saying, stop looking at race and gender groups, focus on individual merit. If you use quotas or try to tilt the scales, you yourself are violating civil rights law.
That's the federal position. But then you have California,
which is moving in the exact opposite direction.
The polar opposite direction.
Yeah.
You have laws like SB 11137, which actually codifies intersectionality in discrimination law. It says employers can be liable for discrimination based on a combination of protected characteristics, race, gender, age, and so on.
So just to make this real, imagine you're a manager in 2026. The feds are telling you to be colorblind and ignore group identity.
And California law is telling you to be hyper aware of it, to track it, and to manage for it.
It is the ultimate employer's dilemma. A manager is caught between a federal mandate to ignore DEI and a state mandate to enforce it. To comply with one is to potentially violate the other.
You're legally trapped. And then, just to make it more fun, we have the whole new AI layer.
Right. The new frontier of liability. We have things like the Artificial Intelligence Consumer Protection Act in New York and similar laws popping up in Colorado. Employers now have to audit their AI hiring and management tools for bias.
So let's go back to David from our first story. If he used an AI tool to help evaluate his team's performance,
he could now be sued not just for retaliation, but for algorithmic bias.
and here's the trap. If he audits the AI and finds it's biased according to California's intersectional standards, and then he tries to fix it to meet those standards,
He might run afoul of the federal executive order, which bans manipulating outcomes based on group identity.
it creates a brand new risk vector where every tool an employer uses to try and be objective is itself a potential liability.
And we also have pay transparency laws, California's SB 11162.
You have to disclose pay scales and job postings. Again, the intention is good. It's about fairness. But when you combine that with the expansion of pay equity definitions, it just adds another layer. If Marcus, the logistics guy, paid his new driver less than another driver, maybe for perfectly valid reasons like experience or a better safety record, the law's substantially similar work clause creates automatic liability. The transparency law provides the exact data points for the lawsuit.
So, if we put all of this together, the death of at-will, the therapeutic expectations, the economic drag, and these contradictory mandates for 2026, what's the synthesis way?
The cumulative effect is a paralysis of action. The intersection of all these factors makes the simple act of employment a high-stakes legal gamble. It becomes safer for an employer to do nothing.
Safer not to hire, safer not to fire.
And safer not to give honest, critical feedback. You just manage for mediocrity because it's less risky.
We started this whole deep dive with the story of Sarah and the myth of the manager's at-will shield. We've journeyed through the reality of the 90-day retaliation presumption that makes that shield so porous.
We've looked at the sociological shift from a merit-based culture to a therapeutic one, just as Lash predicted all those years ago.
And we've seen the real, measurable economic impact, the flight of venture capital, and the exodus of small businesses like Marcus's.
It really paints a picture where protection comes with a very, very high price.
And I think that's the core of it, really. We often assume that more legal protections automatically lead to a better quality of life for workers. But if the cost of that protection is the erosion of merit, the infantilization of the workforce, and the flight of economic opportunity, have we actually built a haven in a heartless world, or have we just built a cage? When the law treats every employee as a potential victim and every employer as a potential predator, the one thing that inevitably dies is the trust required to build something great together.